Morning, everyone.
Okay, good morning.
Good morning.
Mr. Pinal, Mr. Corriente, I don't know if you've done Zoom oral arguments before.
Done one.
One.
Okay, so you should be able to see a clock there so you can keep track of your time. But Mr. Pinal, how much time do you wish to reserve?
5 minutes, Your Honor.
Okay. Also, I just need to advise you that these arguments are being streamed so the public can view them as well. And of course, I believe you both know the other members of the panel, Judge Orfinger and Judge Lambert. Mr. Pinal, you may proceed with your argument.
Thank you, Judge. May it please the court, my name is William Pinnell and I represent Matthew Tibbetts, the appellant in this case. As the court is aware, Mr. Tibbetts was acquitted of 5 counts and found guilty of 11 counts. It's our position that the conflicting verdicts established that this was a close case where there is a reasonable probability that the errors of the trial court affected the outcome of the trial. It's clear based on the record that the jury did not find the alleged victim to be entirely credible. As noted in our briefs, the trial court committed 3 separate errors in this case. Both individually and cumulatively, they require a reversal of Mr. Tibbetts' convictions. Initially, the trial court failed to instruct or clarify for the jury that the state was required to prove that each of the charged offenses occurred during the time period alleged in the third amended information. This is a case about a confused jury trying their best to diligently reach a verdict and the trial judge's failure to clear up their confusion. The state charged 16 offenses over 6 different time periods and 3 specific criminal acts constituting sexual battery over 5 distinct time periods. Without being advised that the date ranges were relevant and that the state needed to prove that each offense occurred during the alleged time period, there was no way for the jury to distinguish between the individual offenses. And without them making that distinguishment or making the finding that the offenses occurred during the alleged time periods, the jury may have convicted Mr. Tibbetts based on all 5 counts based on a single act or based on multiple acts during a single time frame, which would not be as charged in the information. So this isn't not a case where we have to guess whether the jury was confused or not. Initially, the jury asked for a calendar. They were not given that. Then they were asked a question: do the crimes for each count have to have occurred in the date range listed above each count in the instructions? And in response, the trial judge himself said 10 separate times that he believed the jury was confused. And he was concerned about the state's request that the jury be instructed that the state not be required to prove the offense occurred during the alleged range. Over and over again, he said that this case was argued and presented with the dates being material and relevant, and that the jury was confused. The prosecutor himself agreed twice that the jury was confused. The defense lawyer repeatedly argued that the only answer to the question was a simple yes. 11 separate times the defense lawyer made that argument.
Why would the answer be yes if it's not an element of the crime?
Your Honor, it's certainly not an element of sexual battery, but by alleging it over 5 separate time periods, the state has now made it a material issue for the jury's consideration. Otherwise, there's no way to distinguish between the 5 separate times the same act was charged. The jury would be looking at instructions and they would have no way to distinguish between counts 1, 4, and 7 because they were all alleged the same act. And the case law is clear that where multiple counts are alleged of the same act, the state has to prove that it occurred during the relevant time period. There's cases from the 2nd, 4th, and from this court, including the Swain case, where there's multiple time periods. The state has to prove that the alleged offenses occurred during each individual time period. So it's not an element of sexual battery, but it's a material fact that the jury must find in this case because of the separate time periods. And under Rule .3410A, the trial court has the ability to give additional instructions in response to a request from the jury. And the Florida Supreme Court says the yardsticks yardstick for measuring jury instructions is clarity, and where a jury is confused, the court must exercise its sound discretion. And it's our position that the judge did not exercise sound discretion by not giving the simple answer yes to the jury's question. It's unrefuted, and everybody agreed, the prosecutor, the defense lawyer, and the judge, that the jury was confused, and the judge did nothing to allay that confusion. This court has said in many cases that the defendant is entitled to have the charge proven against him as alleged in the information. The fourth DCA, the second DCA, and this court in Swaim has said where there's multiple offenses over multiple time periods, the state is required to prove beyond a reasonable doubt that each offense occurred during the alleged period of time. The Ramos case says that vagueness is allowed on dates where there's one offense, but when there's separate counts with different time periods, greater specificity is required. And that's what we have here, the special rule that if there's multiple offenses over multiple time periods, the state has to prove that, and by definition, then the jury has to make that finding.
Was there a bill of particulars requested in this case?
There was, Your Honor. There was multiple statements of particulars requested. Those statements of particulars were denied, but in each instance where the statement of particulars was requested, the state amended the information to add additional counts and to change the dates of the alleged offenses. So one of the purposes, as this court has said in Jones, of putting time allegations in the information is to prevent a double jeopardy violation. Clearly, it would not be constitutional to have 5 convictions of the same crime based on the same act. It would also not be proper to have multiple convictions based on multiple acts during the same time period where only one count is alleged during that time frame. And without the jury giving the instructions that the dates are relevant and material, there's no way to ensure that didn't occur in this case. And it's important under the facts of this case, because throughout the case, from the opening instructions from the judge, through opening statement, through the testimony of the alleged victim, through closing, the dates were mentioned over and over again as relevant and material. Additionally, the alleged victim during her testimony had great uncertainty about dates, and on cross-examination, the fact that her memory or recall or ability to testify to specific dates evolved over time. When she gave her initial statement to the prosecutor in April 2017 and the depo to the defense lawyer in 2018, she had specific dates. Those dates changed in the second trial in this case. Initially, she said that the alleged act that she said occurred on Valentine's Day, occurred in 2016. By the time we get to trial, she's not sure whether it's 2014, 15, or 16. Same thing about her 17th birthday. First, she says it's on her birthday, then it's maybe a week after, she's not sure. So her testimony on dates evolves, and that's a significant part of the impeachment in this case. So under the unique facts of this case, this error is particularly prejudicial. The state prepared the jury instructions in this case. The judge has the duty to ensure the jury is properly instructed. The question clearly exhibited confusion on part of the jury, and the only answer to the question should have been a simple yes. And for some reason, the trial judge, despite acknowledging the confusion, despite acknowledging that the case was presented and argued that the dates were material throughout, the judge did not answer the question correctly. The state relies on the Perlman and Tingley cases on this.
Correctly.
I'm sorry, Your Honor, I didn't hear the question.
He did not answer the question incorrectly. He just basically said, go back and read the instructions again, which is his discretion under the rule, isn't it?
It is his discretion, but he has a duty to make sure that the jury is properly instructed and that they clearly understand the law.
Well, each instruction had the date at the title of the instruction. He orally read the dates for each count. And so then he told him, go back and read the instructions. Yeah, I mean, he could have said yes, I get that. He didn't, but you're saying that that's so horrible, we have to reverse it because it's something no other judge in the state of Florida has done. I guess under the abuse of discretion standard.
I am, Your Honor. The problem is that the dates are only in the caption, and the jury's never instructed that the state has to prove those dates. And the jury, again, we don't have to guess. The jury's confused by that fact and confused by the state's inconsistent arguments during closing. So they asked a simple question: do we have to find that these offenses occurred during those dates? And the answer is yes. So their confusion was not fixed. They weren't given a clear and a clarity answer as required by the Supreme Court in the rule. So we do believe it's an abuse of discretion. And this is a close case with some acquittals and some guilty. So the jury was confused, and they're trying to get the right verdict. They're asking for a calendar. They're asking the question, and they don't get an answer. So it's our position that by failing to properly clarify under the cases, this court's decision in Swain, the district court decision on Cardona, McLean, Ramos, and Gamble, that the dates need to be proved, that reversal is required. Additionally, it's our position that the court abused its discretion by concluding and admitting evidence of uncharged collateral crimes before the alleged offenses in this case. It's our position under the Roll and Sabine cases from the second DCA that this information was not necessary in order for the alleged victim to give an intelligent account of the alleged offenses. The Roll case involved similar facts where the charged offenses included where the victim was between 5 and 13, and the trial judge admitted evidence about acts that occurred prior to that, and they said it was not necessary and prejudicial and reversed. The Sabine case from the second DCA, very similar to our case, there was 20 counts of sexual misconduct against the defendant in that case, ranging from the age of 11 to 15 of the alleged victim. And then the state introduced evidence of conduct when the alleged victim was 8. And the district court said that evidence of collateral crimes was not necessary to explain the conduct that the victim gave testimony about during the 4-year charge period. Here we have testimony about an alleged touching in Alabama and an alleged sexual battery in Seminole County, uncharged prior to the charged offenses. Nothing about those offenses was necessary for the jury to hear to understand the charged offenses. The alleged victim gave testimony about 16 charged offenses, detailed testimony. The only purpose of these 2 prior instances was to show that the defendant allegedly had a propensity to commit these crimes. So under Sabine,
when was the first time that the defendant, or the evidence, the first time the defendant told the victim, don't tell your mother? Is that in Alabama, or?
I believe it's in Alabama, Your Honor.
Okay, so is that relevant to, as far as, making the rest of her testimony make sense as to why she didn't say anything to her mother a couple of years later?
I don't think so, Your Honor. I think that she can still give an accurate and description of what she says happened in the charged offenses.
Right, but the jury would wonder why she hadn't told her mother of these events, when she was 14, if she didn't mention the first event of 14 of sexual encounter with the defendant, correct?
Well, she didn't tell her mother.
The jury, that's something the jury would be interested in, I'm sure.
But the jury certainly didn't. The alleged victim did not tell her mother anything occurred till after any of these alleged offenses. So they could have asked that question based on the testimony of the actual charged offenses. So she could have gave that explanation at that point. There was no reason to bring in these prior uncharged conduct for that purpose. And the state seeks to rely on Williams' rule, and importantly, the trial judge in this case never made the findings of clear and convincing evidence to find evidence admissible as Williams' rule, because the state didn't ask them to. So the state's argument that this evidence is admissible as Williams' rule is not properly preserved. It was waived in the trial court and should not be considered as an alternative basis to affirm in this case. The fact that in Sabine and Roll, obviously the offenses in those cases occurred before and they were earlier. Just the fact that they're earlier doesn't make them relevant and inextricably intertwined. And it's our position under those two cases, Mr. Tibbetts is entitled to a new trial based on the introduction of the collateral crime evidence that was not necessary to give an intelligent account to the jury on the charged offenses. I'll reserve the rest of my time for rebuttal.
All right, thank you.
May it please the court. My name is Carmen Corrente, representing the state. To start with, this is an allegation in the first issue that there was a double jeopardy violation. Either that or it was fundamental error not to use an interrogatory for these verdicts. There is no support for using interrogatory, special interrogatories for these verdicts. And there was no double jeopardy. It's clearly marked with the verdict form, guilty as charged in the information. If the jury were to go and look back at the information, they would find it clearly marked with the dates. And the jury instructions followed all of that. The state was very careful to make sure there weren't two convictions for the same period of time for the same crime. They simply broke it out. Now, whether or not that caused confusion with the jury, I think they were confused about other matters. They wanted clarification on whether it had to be proven within those dates. But the entire state case was based on those dates. It was split up that way. And the verdict matched the information. All they had to do was look at the verdict and say, as charged in the information. The entire information then becomes part of that crime. And they, on top of everything, they found some were acquittals during the same periods of time. They asked for a calendar. That indicates that they were very concerned about the dates, that they were looking at the dates and they broke it down that way. And they did not convict and could not have convicted in a violation of double jeopardy. So if there's no violation of double jeopardy, and there's no fundamental error for the way this was done, because it didn't negate his defense. It didn't reach down into the basis of the verdict. I think point one is clearly in the favor of the state. As to point two, I mentioned Williams rule evidence in here, even though this was inextricably intertwined, and I'll try to say that as carefully as possible. But you don't even need a hearing if it's intertwined. You just present that, and a motion in limine and other pretrial motions handle that. This was actually a noticed, and don't forget, it's the second trial, so it's not a surprise. It was actually noticed, there was a hearing on it, and the judge did find it was intertwined. The state's position, and why Williams rule was mentioned, is that it could have met the clear and convincing. And the reason is that it's intertwined and could have met the clear and convincing is because it set the stage for this crime. This series of crimes, don't forget, we have a familial or custodial situation here, not contested like it was in some of the other cases relied upon by appellant. And with that fact comes a relaxed evidentiary admission for corroboration of the victim. The very first time that the defendant in this case touched her inappropriately was in Alabama. That was number one. If the state had started out with, yes, we had sexual intercourse at age 14, just jumped right into it, it would have missed how it got to that point. The Alabama was the first touching. Then when they got back to the Seminole County apartment, started going under her clothes and started giving her the direction don't tell your mother, this is a secret between us. Then the relationship grows. There are cards and letters, but there were 3 incidences, including one in Daytona Beach, where he committed some of these crimes or committed crimes while he was in custodial control of her, had authority over her, and he took advantage of her everywhere he could, starting with the grooming all the way through. So the state feels that the evidence in this case, even if it was error, would have been harmless because it clearly wasn't a feature. You can go through that entire 1,000 or more page trial and hardly find a reference to it. It was brought up 3 times, each time with the cautionary instruction. And then in closing, they got the cautionary instruction. The jury wasn't swayed by it because they acquitted him on many of the counts. They didn't just go ahead and convict him on all. And the parties all worked together on the instructions. And as far as the, I don't know if the court wants me to address the counsel's comments.
Yeah, go ahead.
Pardon me. This court in Woods that I cited clearly said that where they talk about credibility, where an assistant state attorney, it's a permissible argument. When you talk about the credibility of a victim, it's a permissible argument when it's saying basically that the witness was worthy of belief. Here, counsel said, but he said, I believe the testimony or the evidence that was presented was credible. He didn't say, I believe she was truthful. He was saying they allege this, they allege recent fabrication, they allege a lot of things, but her story was credible. It's the story that was credible.
What if the prosecutor said, in my opinion, having listened to the evidence during this trial, in my opinion, BZ, the victim, was the credible witness. Her testimony is credible, or the most.
No,
Would that
yeah,
be?
not in my opinion, and that wasn't said. It was I believe that the testimony was credible, which means I believe that it was understandable, logical, made sense. Credible means made sense. It doesn't mean it was true.
But what if the prosecutor says, okay, I've listened to all the testimony just as you have, jury, and based on that, I think the victim's the most credible witness here. Is that okay?
Well, I wouldn't approve of that myself, Your Honor, but if made to, I would be arguing that depending on the context of the, you have to look at the entire closing argument.
Right.
The state mentioned that, what, 3 times? I just don't see fundamental error, and I'm hoping that the court does not feel that that's fundamental either as well, especially considering the Woods case. But if there are no further questions.
So if the prosecutor said, well, I submit that the victim's response was credible to the question about how do you remember it being on Valentine's Day or what have you, that would be a much better response or comment by the prosecutor, because obviously.
Well, I think so, because it fits in with the facts is what that infers, that it fits in with how this thing has been set up in the facts.
Well, I mean, both sides at trial, when they did closing, they argued to the jury why one side or the other side's evidence is not credible or believable. It's just
Exactly.
Across the line and say, okay, guess what? In my opinion, because that suggests that the prosecutor has some other outside the courtroom knowledge about things that he or she is now passing on to the jury to consider when they deliberate, and that becomes problematic. But
Correct.
certainly defense counsel will argue that the state's witnesses are not credible.
Exactly. And it happens every time. And especially in this case, that's all they attacked. They gave the motive that, first of all, she didn't like the new stepdad that was involved with her mom, didn't want to see her mom with someone else. Then afterward, he stopped her from getting a boyfriend and kept watching her, so she needed to get rid of him. So this was all a claim that it was fabricated from the beginning.
You got the
I think
boyfriend
the state-
fired, right?
Pardon?
You got the boyfriend fired from his job at Panera's, right?
Absolutely. So if there are no other questions, we'd ask you to affirm. Thank you.
All right, Mr. Pennell.
Sure. May it please the court. Initially, this issue is not reviewed for fundamental error on issue 1. Trial counsel asked 10 times for the judge to answer the question yes, and the trial judge refused to do so. So it's fully preserved. The judge was given a chance to clear up the confusion and chose not to do so. There's a danger of a double jeopardy violation. We didn't need an interrogatory verdict form. We just needed a clear instruction and a clear response to the jury's question exhibiting their confusion. And we didn't get that.
Isn't that the argument in all these type of cases when it's a span of time that this sex crime against a child happened between date A and date B, and the child says, yeah, he did that to me 28 times, then that's the argument in all cases. Certainly wasn't trial when I was a trial judge. So how is that? I mean, that's always a double jeopardy problem. How does this case unique here in this context?
Well, it's the five separate time periods. So it's the 5 separate time periods where the same 3 acts are alleged, and there's no way for the jury to distinguish between those 5 time periods unless they know the time periods are relevant. And they ask the judge, are they relevant? And the judge doesn't tell them yes. And for double jeopardy purposes, the Florida Supreme Court in the Lee case says that it's not evidentiary sufficiency, whether there's evidence of all 5 time periods, it's the dates and the information that are important. So the jury needs to be told that the dates are important and material. And they're trying to get it right. They're confused. And for some reason, the state fights them and is unwilling to let them hear the answer yes. And the judge goes along with that. So, I mean, it's just fundamental that the jury needs to be given the correct law. And under all the DCA cases that I've cited, Cardona, the long list of cases, the state has to prove within the time period. Cardona, McLean, Ramos, Gamble, and this court's decision in Swain, the state is specifically required to prove that the alleged offenses occurred during the time period. The jury asks the judge whether that's true, and he doesn't tell them yes. And the written instructions are unclear because it's just in the caption, but it's not in the section where it says to prove these offenses, the state has to establish these facts. So the jury is never correctly told that they have to find these alleged incidents occurred during time periods. And because the victim was challenged on her memory on dates and her evolving inability to recall specific dates, under the facts of this specific case, it's prejudicial to Mr. Tibbetts. The state, when they chose to amend the information and make 5 separate time periods, made the dates material. They're not elements of sexual battery, but the material facts that must be proven to the jury. And the jury was never told that either in the written instructions or when they asked for clarification. And for that reason, the court should grant Mr. Tibbetts a new trial. The state's argument that when the prosecutor in closing argument says that I think that the alleged victim gave a credible explanation is not a synonym for truthfulness is, in my opinion, absurd. Credible is a synonym for truthfulness. The case law is clear from this court in service, from the 4th DCA and Ramos, that the lawyer, the prosecutor cannot give a personal opinion.
Well, how about if a defense attorney actually objects during the trial when they do it the first time so that the judge can sit them down and say, okay, look, instead of saying, I think, or in my opinion, just say, I submit that this was credible, it was a credible explanation for why she did that. Yeah,
that would certainly be a better situation, but this court has said that where there's clearly improper testimony or argument, that the judge has an obligation to step in. Can't just let improper things be said over and over again. And I can't think of a more clear example of saying where he says over and over again, I believe she's credible.
He said, I think. So I mean, if he would have said, if he said, I submit it's a credible explanation, then we wouldn't be having this discussion today.
I think once you start using the word I think he's got a problem. I think it's improper. Right? And I think in the Ramos case, the prosecutor said, quote, I believe she testified truthfully to you. And they said that was improper. So it's blatantly improper. The trial judge should have stepped in. Between this error and the other errors, cumulatively, Mr. Tibbetts was not given a fair trial. There was conflicting verdicts. this court should reverse and remand for a new trial on the counts of conviction. Thank you.
Thank you both. I'll conclude this argument. We'll return for our second argument of the morning at 10 o'clock. Thank you.